Dobré ráno, dámy a pánové. Good morning, ladies and gentlemen. As this is the first panel, I have been asked by the organizers to make an organizational announcement concerning the application Slido. That this is the application that simplifies moderation of discussions and provides us with opportunity to quick interactive polls. And through this application, you can ask questions and answer the conference polls. You can also vote for the questions of other participants that you find interesting and make them more likely to be answered. Now, let me turn to the content of this panel and first of all, thank the organizers for inviting me. It's a real pleasure and honor for me to act as a moderator of this first plenary session, which will focus on experiences of immigration detention of children and of findings from the field. When I think or when I hear about child immigration detention, I think of a Nigerian girl I met in Lampedusa. Let's call her Ivona. She was 12 and unaccompanied. She was stuck in the hotspot reception facility for almost 2 months. She complained about almost everything: the food, the inappropriate clothing, the cold water in the showers, and the blocked toilets. Ivona was held in the space for minors, but never fully separated from adults, who could come and go through a hole in the fence. She wasn't informed about her rights in terms of international protection. She did not have any guardian or other support. She did not feel comfortable talking to me because I was just like the white man who put her in jail. The story of how she arrived in Lampedusa made me think that she had been trafficked. And instead of giving her assistance for a potential trauma, she was put in detention. I also think of another story, that of an Afghani family with 3 children detained in a removal center in Turkey. They had been handcuffed and returned from Greece. They were stuck in a small room. The children, aged 13, 14, and 18, did not attend school. They were all terrified by the guards who had beaten one of the children after she had drawn something on the walls of their small room. The beaten girl, aged 13, was still shaking when telling me the story of how it all happened. They were waiting their turn to claim international protection, but could not understand the documents in Turkish which they had been given and required to sign. And I also remember the scene in Reske, the transit zone in Hungary, where Arman, a boy aged 8, was playing in a minuscule courtyard in the middle of several containers housing 5 to 6 families. The fences around the space were 4 meters high. They could not get out of there. The boy looked me in the eye and asked me, "What crime have we committed? Why are we in prison?" Detention is a traumatic experience for adults. Its effects on children, and in particular on migrant and refugee children, is exacerbated by their vulnerability as children, as migrants, and often as unaccompanied and undocumented. It has severe negative short and long-term effects on children's physical and mental health. Put otherwise, they lose hope, they lose dreams, and they lose their sense of safety. This has a terrible impact on their emotional and cognitive development and may lead to lifelong trauma. And I have seen many apathetic children in Greece and in Italy. My fact-finding missions in different member states of the Council of Europe have been particularly instrumental in collecting findings and in making proposals for action. The deprivation of liberty of migrant and refugee children has been a recurrent issue in all but one fact-finding mission report. In Greece, the lack of any alternatives to detention seemed to be a structural problem. In Turkey, the possible detention of children in removal centers was anticipated. In Italy, the shortage of places in second reception facilities resulted in longer detention of unaccompanied minors in first reception centers, which were not suitably adapted for their needs. In Hungary, the detention in transit zone of children aged between 14 and 18 was automatic and systematic for 60 days or sometimes even more until their asylum claims were processed and eventual deportation decisions enforced. The law deprived these children from the legal protection of guardianship because they were automatically deemed to have full legal capacity. From my missions, I also know that there is nothing like hearing about the immigration detention from people who experience it themselves. Reports and statistics cannot fully express the effect of such an experience. This is why this session is opened by Ms. Pinar Aksu. She was 8 when she was detained alone with her parents and 2 siblings for over 2 months in an immigration removal centre in rural Scotland and then in England. Pinar considers herself lucky for being released and offered leave to remain. In the meantime, she completed an undergraduate degree in community development and a master's degree in human rights and international politics, and is now actively involved with several campaigning groups promoting integration and opposing racism and detention. I invite her to share with us her personal perspective and an understanding of the impact detention has had on her life and on her life choices. Pinar, you have the floor.
Thank you. My name is Pinar Aksu. I was born in Turkey, but as you mentioned, when I was 8 years old, my family started seeking asylum in the UK. The year was 2001, and my family was one of the many who got moved from London to Scotland as part of the dispersal programme. As asylum seekers in the UK, life was not easy for us. You were not allowed to work, receiving just £36 per week to live on. There were many other barriers. You can only go to school. When it comes to college, you can study to certain levels and cannot get higher qualification. You cannot attend university because you will be counted as an international student, so therefore you'll be charged very high fees. Every day was a struggle during these years, but then things got worse. The UK Home Office started detaining a lot of families, including mine. My parents, my 2 siblings, and I were detained for over 2 months in an immigration removal centre called Degrading, which is in rural Scotland, and in Yarlswood in England. When we were detained, it was on my sister's 4th birthday, and in the UK there is a system where you go in to sign on to prove that you're in the country. So it was the same day after school when we were out from school, we went to sign on, and that's when we got detained. I describe Yarlswood and Degrading as a prison, as I don't see any difference between a detention centre and a prison. We did not know when we will be out, as more families arrived each day. We were treated as criminals. Governments may use different words to make these policies sound acceptable. However, it is the same as I was being deprived of my liberty without cause. Our rights as citizens were taken away. As a child at the time, I saw many things that no child should see. I saw violence as families resisted being returned to the dangers of their homeland against their wishes. I even saw people committing suicide as they gave up hope and felt that was the only way and the only option left for them to escape. The UK has no time limit on detention, so no one knew when they would be out, which made it difficult to have hope. We were not criminals, we did nothing wrong, but even criminals in prison know when they will be out. It was challenging times for myself and for my family. It is forgotten that people seeking safety are not just numbers or a case file. They are human beings with experiences. My family was one of the lucky who were released from detention centre. As soon after receiving our leave to remain papers, which is the refugee status in the UK, this was due to our friends and activists organising grassroots campaigning, from support from politicians, support from the community, and support from grassroots groups. The hard work of the local campaigning groups such as Glasgow Campaign to Welcome Refugees, the Unity Centre, Right to Remain, and many more were to save many children, families and individuals from detention removal centres across Scotland and England. Now I live in Scotland and I work with people who are seeking asylum and refugee. as a project coordinator, and I also practice theatre as well. There are still 13 immigration detention and removal centres across UK, which are controlled by prison services and private sector companies, such as Serco and G4S. And these are the same companies who operate prisons across the world. So obviously you don't expect them to create a suitable condition for children. I campaigned for the closure of Dungavel Removal Centre in Scotland, and I provided evidence to end child detention. And Dungavel Removal Centre in Scotland is the only detention centre. In Scotland in 2010, it was announced that detention of children at Dungavel would be ended. This was a remarkable success as it showed what a single-issue campaign can achieve. Here we saw a united community with trade unions, politicians, and the broader public working to make things better for the children. When I look back at my experience, it is clear that our first expression of seeking asylum was far better than the time I spent in detention. I have now learned that the first program I was involved in is the kind that many experts call an alternative to detention, allowing for people to live in the community while they wait for their migrant and migration status to be clarified. The work that everyone is doing at different capacity to make alternatives to detention available across Europe is important. Especially even short periods in detention can have horrible, long-lasting impacts on child health and development. Sadly, child detention still occurs across the UK, despite this promise in 2010 when an alternative detention was built called Cedars. Unfortunately, it is expected that child detention in the UK in 2018 will rise again, with the recent closure of Cedars and children being transferred to Tinsley House Adult Detention Centre. No child should be in detention, but if they are being detained, it is obviously better that significant efforts are put in place to make a facility safe for children, rather than putting them in a prison for adults. One important strategy to help end child detention is to engage with the local people, building connections and organising meetings, multicultural community events and marches to welcome refugees, such as the annual UN Anti-Racism Day, which helps to create a platform to understand one another. These types of events help to educate and connect people so they know that there is not them and us, there is only humans, one human race. Engagement relies on dialogue and understanding, and campaigns at local and national level must be elemented and that dispel myths about migrants and refugees, and works equally to empower refugees and migrants and show the positive role that we play in the community. Alternative to detention, where children can live in-house with their family, has been shown to enable people to meet their basic needs. It costs less, allows them to support, and it is more humane. We must ensure that alternatives to detention are exactly this, and not alternative forms of detention. For me and many of the world's leading UN experts, a person should not be detained for seeking safety and refuge in another country, let alone a child. It is a very basic human right not to be tortured or treated inhumanely and not to be discriminated based on race, colour, religion and birthplace. The following are my recommendations for alternatives to detention. Firstly, it is important to create local and national campaigns and network of sports which provide true stories to reflect the human side of the process of seeking asylum. I was involved with the Living Library event at the Council of Europe, coordinated by the Global Campaign to End Child Detention. The parliamentarians could borrow me or other experts in the Living Library for 10 minutes conversation. It added a human face to the situation, beyond dry statistics and reports. It created discussion, dialogue, and understanding, which was a great way to start the 3-year parliamentary campaign to end child immigration detention. Secondly, it is important to have a strategy to engage politicians and all of the arms of government system. It is important to show the human cost of policies, but it is also important that political will is built. Sometimes these two can be challenging to do at the same time, with politicians defending the ethics of their current position. We must understand how we can use the current political environment to build government engagement. Thirdly, child rights organizations need to do more by consistently using evidence and international instruments such as the human rights treaties, the ICRC, optional protocol to the Convention Against Torture, and the Refugee Convention. If we don't use these international legal instruments, then it means that there is no point of them having in the first place. It is important to use the legal instruments as a tool for the country to change its policy. The global compacts, which is being created at the moment, present an opportunity for us to hold our governments to account. The commitments they have made in the New York Declaration to work towards ending child detention could be nothing more if we do not find a way to motivate and implement international legal standards. In my opinion, no child, no person should be ever detained. What is needed most and what is needed now is action. Action to change policy and end child detention. Action to end wars and poverty that force people to become refugees. Using methods such as age assessment and detention will only traumatize the child, causing longer damage to a child's development. And especially now, knowing that there are 10,000 children missing in the UK is horrendous, and this should be an element which pushes us to make change. In the UK, the immigration and asylum system needs to go through a major reforms, starting with a 28-day time limit and working towards essentially ending detention, as the UK is the only country in Europe which doesn't have a time limit for detention. So you could be detained for a month, for a week, or you could be detained for years. Thanks everyone for listening to my voice and experience. I am just one voice. There are so many other voices being silenced under immigration detention centers. Thank you.
Well, thank you very much, Ms. Aksu, for your heartfelt recount. Immigration detention centers are mostly out of sight and out of mind to society. So having you here and sharing personally this experience, it's important to put immigration detention of children inside and in the mind of the general public. And I would like also to thank you for the recommendation you made, and I'm sure they will be taken into consideration when the concrete way forward will be formulated. Thank you. Many mandates carry out inspections and monitoring in places where children can be deprived of their liberty. Their reports are another credible manner of exposing such experiences to the general public. Among them, the European Committee for the Prevention of Torture and Inhuman or Degrading Treatment or Punishment and International Committee of the Red Cross are two of the most reputable. Our next two speakers, representing CPT and ICRC respectively, are invited to share their findings on immigration detention of children. So now I will give the floor to Ms. Ivona Todorovska, a member of the CPT. You have the floor.
Thank you, Mr. Chair. Your Excellencies, ladies and gentlemen, respected colleagues, dear friends, it is a great honor to take part in this conference and be able to present CPT's work, findings and standards in the area of immigration detention, in particular when it comes to immigration detention of children. And I would like to express gratitude to the Czech Republic for organizing this conference, which will allow us to discuss this very contemporary and important topic in the course of the next 2 days. From the very outset of my expose, I would like to highlight that immigration detention is a primary focus of the work of the CPT. The CPT has carried out hundreds of visits to immigration detention facilities and interviewed detained migrants and has developed its jurisprudence and set of standards which are based on direct findings of such visits. During my outline, I wish to present summary findings from some more recent missions and visits carried out by the CPT to illustrate which of the standards Council of Europe countries face difficulties in implementing and where certain improvements have been noted when it comes to immigration detention of children. Having said that, I must reiterate that the CPT concurs with the United Nations Committee on the Rights of the Child which considers that unaccompanied or separated children should not, as a general rule, be detained, and detention cannot be justified solely on the purpose of the child being unaccompanied or separated, or on their migratory or resident status, or the lack of one thereof. Further, CPT's position is fully aligned with other Council of Europe bodies, such as the Parliamentary Assembly and the Commissioner for Human Rights, which on numerous occasions have stated that unaccompanied children should not be detained. Equally, the CPT considers that accommodation of children accompanying their parents in a detention center can have a severe negative psychological effect on the children's development and well-being, particularly when the child is young. The placement of minors with their parents in a detention center should only occur as a last resort and in very exceptional circumstances. When such placement cannot be avoided, its duration should be as short as possible. While the CPT maintains a strong position that every effort should be made to avoid the deprivation of liberty of an irregular migrant child, it also pursues implementation of a set of specific standards when children are exceptionally detained under immigration detention laws and framework in order to provide minimum standards and safeguards that would prevent inhuman or degrading treatment or punishment of migrant children. To begin with, during its visit, the CPT has come across migrant children detained in a variety of locations and phases of the process, such as at entry, transit, and border areas, when migrant children and adults are detained to prevent irregular entry or to determine their identity and status. The CPT has also met detained children while waiting outcome of first or second instance immigration or asylum procedure, or when detention of migrant children occurs to ensure removal from the country. One of the main concerns voiced by the CPT is the practice of detaining migrant children in police stations for prolonged periods of time, or detaining children in ad hoc detention facilities, such as adapted containers and former garages, or even in former prison wings. Children whose only offense was to the most related to their immigration status were held in police cells for a prolonged period of times, days, weeks, and in few occasions for months to an end. In some cases, they were detained together with unrelated adults, which have been detained under criminal legislation and criminal charges. They were kept in cage-like conditions with no proper clothing or sleeping quarters and had no access to outdoor activities at all and had no access to shower facilities. The CPT clearly regards such practices to be unacceptable, and in occasions where it faced such situation, it had revoked Article 8, Paragraph 5 of the Convention and requested states to stop such practices immediately and undertake efforts to remedy the situation. While indeed many countries introduced policies and undertaken measures to end detention of unaccompanied children, the CPT has met children which are detained pending outcome of lengthy and complicated age assessment procedures. In CPT view, persons who claim to be juveniles should be treated as such until proven otherwise, unless the claim is manifestly unfounded. The provision of information on the reasons for detention and rights and responsibility of the migrants has seen certain improvements over the past years when it comes to availability of such information in general and availability of such information in either written or verbal form in the languages spoken by the migrant children. However, in many cases, the language support is not available at all times when it comes to legal procedures involving the child, or in day-to-day activities within the centers, or is of questionable quality. That leaves the children with difficulties to understand the content and meaning of the written documents they are being provided, or to grasp fully their rights and responsibilities, and consequentially, it creates an ability for them to be more actively included in the processes and activities that pertain to their well-being and future. The CPT recommends that owing to the special vulnerability of unaccompanied minors, steps should be taken to ensure that whenever minors are deprived of their liberty, they are always assigned an appropriately trained or sufficiently experienced guardian who effectively protects their rights and keeps them regularly informed about their legal situation. Also, the CPT recommends that review mechanisms should be introduced to monitor the ongoing quality of the guardianship, because from what we have seen in practice, the guardians appointed to unaccompanied minors were usually not sufficiently trained or experienced in working with vulnerable and possibly traumatized minors. In addition, in practice, the guardians did not maintain regular or meaningful contact with the minor, who is left in limbo awaiting for an information on his or her future. On the topic of vulnerabilities, the CPT has also noted that in many situations, when children are detained, no assessment of their particular vulnerabilities has been carried out by qualified professionals, even in cases when the children in question are coming from war-torn and from countries with high rates of human rights abuses, or have passed through countries like Libya, where the likelihood to have experienced exploitation and abuse during the journey is quite common. In such situations, the CPT considers that as soon as possible, after the presence of an unaccompanied minor becomes known to the authorities, a professional qualified person should conduct an initial interview in a language and in a form the child understands. An assessment should be made of the child's particular vulnerabilities, including from the standpoint of age, health, psychosocial factors, and other protection needs, and every effort should be made to facilitate the immediate release from a detention facility and their placement in more appropriate care. In lieu with the lack of screening for vulnerabilities during its work, the CPT has noted also the lack of psychological and psychiatric assistance in many of the immigration detention establishments visited. While in some institutions, in certain countries, there are some arrangements within or outside of the centers, in many no psychological care or support was available. Another aspect which has been debated by the CPT is that certain standards in immigration detentions are simply replicated from standards applied in prison settings. For example, in many countries, the right to daily outdoor exercise for immigration detainees is limited to 1 hour a day, a standard which is usually applied when it comes to detention of remand prisoners detained under criminal charges. This has created situations which have been criticized by the CPT, where children who are at important stage of physical and psychosocial development and who have not committed any criminal offense or represent danger to others, to be allowed to be in open space only 1 hour a day. The same applies when it comes to the contact with the outside world, where immigration detainees, including children, are not allowed to keep their mobile phones that could facilitate contacts with families, or are allowed to have visits only once per week in supervised conditions, or even in some cases through partitioned glass. The CPT does not see any reason why persons held under aliens legislation who are neither convicted nor suspected of criminal offenses should be subject to such arrangements that are usually seen in strict regime prison establishments. When it comes to the access to education of children in immigration detention, there have been certain efforts by member states to provide access to formal or informal education to migrant children within the detention facilities or within the communities nearby. However, efforts vary from country to country. Some centers are equipped with skilled staff that provide socio-educational activities, while in others, there are only guards that have no meaningful contact with the migrants. In CPT's view, children deprived of their liberty should be offered a range of constructive activities, with particular emphasis on enabling a child to continue his or her education. On the very same topic of staff, during some visits, it became apparent that in view of the increasing number of migrants detained in immigration detention facilities, additional staff had to be recruited or deployed hastily, with little time for training in working with migrants, especially with children, and no training was provided on how to diffuse stressful situations, especially those involving unaccompanied minors or families with small children. On the other side, in some countries, it was noted that the management and counselors were sufficient in number, qualification, had different cultural backgrounds, and possessed a wide range of language skills, which contributed to fostering a positive relation and atmosphere between the staff and the detainees. As in the core of the CPT's mandate lies the task to prevent torture or any form of inhuman and degrading treatment and punishment, I would like to mention that regrettably, in some occasions, the CPT visiting delegations members have received allegations of ill treatment of minors by law enforcement officials, either in the face of apprehension or while being accommodated in different detention facilities. Such instances, unfortunately, included reports of physical violence or abuse by law enforcement officials, but also failures to protect the children from abuse by other detainees. These allegations concerned mainly slaps and punches to the face or the abdomen, as well as use of button blows at the moment of apprehension, even when the persons concerned were allegedly not resisting apprehension or after they have been brought under control, during transfer to a police establishment, and during subsequent police questioning of the minor migrants. To summarize, children should be placed in centers designed to cater for their specific needs and staffed with properly trained men and women. Given their particular vulnerability, the CPT recommends that the necessary measures be taken to ensure that unaccompanied and separated minors are always provided with special care and accommodated in open or semi-open establishments specialized for juveniles, such as social welfare or educational institutions, where they will be provided by specialized staff with appropriate care and activities suitable for their age. The CPT recommends that, if necessary, countries should amend relevant legal frameworks accordingly to meet these standards. Let me finish by saying that the topic of administrative detention of migrants remains high on CPT's agenda and focused during visits to countries and places of deprivation of liberty. The reports with findings from the ad hoc visits to Greece in 2016, where the CPT has visited also the reception and identification centers, aka the hotspots, will be released tomorrow. Earlier this year, in July, a similar visit was carried out in Italy, and the results and findings of this visit are expected to be published early next year. In the meantime, more upcoming periodic and ad hoc visits will continue to look into the topic of immigration detention. I thank you for your attention and remain at your disposal for questions.
Thank you very much. Actually, there are already several questions raising here. So thank you for presenting the CPT's findings and also on practices and shortcomings in Europe as far as the detention of children is concerned. And you touched also on the on few issues which are very closely linked to the detention of children, like age assessment, lack of information, guardianship, and there will be panels discussing these issues later on. The work of the Council of Europe and the International Committee of the Red Cross overlap in some crucial issues, while our approach, mandate and methodology are different. So for this reason, I invite Ms. Angela Valenza from ICRC. She's Regional Migration Advisor for Europe and Central Asia, to take the floor.
Thank you very much, Mr. Chair. Your Excellencies, ladies and gentlemen, and colleagues, thank you for inviting us to this important and timely discussion on immigration detention of children. The ICRC welcomed the opportunity to share our perspective with you on this issue. My role will be to briefly present the ICRC experience and observation and highlight key considerations for states in the field of immigration detention, especially that of children. The ICRC has a first-hand understanding and experience of migrants because its humanitarian work with vulnerable migrants in several countries along the migration route. The ICRC mandate, an exclusively humanitarian mission, is grounded in international law. The status of the International Red Cross and Red Crescent movement and resolutions of the International Conference of the Red Cross and Red Crescent. We work together with Red Cross and Red Crescent National Society to guarantee that vulnerable migrants receive protection and assistance they require. Within this framework, we visit detained migrants in both criminal and dedicated immigration detention facilities on our own or in collaboration with national societies. During this visit, we assess whether detained migrants are treated humanly, they are held in conditions that preserve their dignity, they are afforded due process or law, and they are able to maintain contact with the outside world, if they wish to do so. In our dialogue with the authorities, we raise any problem that we identify with the aim of ensuring that states fulfill their obligation under the relevant legislation, including with respect of the principle non-refoulement. So our first message is detention for immigration-related reasons should be avoided. Liberty and alternative to detention should be the norm. Migrants are detained in a significant number of countries for immigration-related reasons. For example, while the authority establish their identity, when they establish their age, when assess their asylum claim, and to prevent them from absconding, in particular prior to deportation. In some instances, migrants in irregular situations are systematically detained, regardless of their personal circumstances. Migrants are sometimes held for long periods of time. Conditions of detention may raise serious humanitarian concern, as facilities that we visit in a number of countries are far from meeting international standards. Overcrowding is a recurrent problem, just as unsanitary conditions and lack of access to adequate and quality health care. Migrants detained for immigration-related reasons are sometimes held with criminal law detainees, and minors may be held with adults. Restrictions imposed on detained migrants sometimes go beyond what is strictly necessary. Staff are often not well trained to care for demographically complex detained populations. The ICRC reminds states that immigration detention should be a measure of last resort, with liberty and alternative detention always considered first. A decision to detain can only be taken on the basis of an individual assessment without discrimination of any kind. It must not be based on a mandatory rule for broad categories of persons. Any detention must be determined to be necessary, reasonable, and proportionate to the legitimate purpose. Conditions of detention for migration-related purpose should be as permissible as possible, and notably less restrictive than those applied in criminal detention setting. Furthermore, the rights of the detainees must be respected, and a number of key procedural safeguards observed, including a periodic review of the justification of continued detention, as required by existing law, and as a matter of policy and good practice. States should commit to ending the detention of children for immigration-related purpose. The best interest of the child shall be a primary consideration in all measures concerning children. Detention has a negative impact on the health and well-being of migrants in general. The detention of especially vulnerable groups, and notably children, is particularly harmful. In 2016, ICRC visited almost 2,500 children in immigration detention in 50 countries worldwide. Our daily work clearly showed that immigration detention is detrimental to children and that child protection safeguards are often inadequate in such setting. Children who have been in detention exhibit increased symptoms of depression, anxiety, post-traumatic stress. Detention can aggravate trauma experienced in a home and transit countries. When children and adults are detained together, children are at increased risk of physical, sexual violence and abuses. Children in detention frequently face physical health and behavior problems, as well as developmental delays. Physical developmental delays may be in part a result from the poor diet or unhygienic conditions. Consequences of detention may persist for long after children have been released, affecting their adjustment to life post-detention, sometimes for a very long period. In the ICRC experience and observation, the best interest of the child is not served in this setting. Yet, thousands of migrant children around the world are detained, sometimes for a prolonged period of time. Unaccompanied children are sometimes held while the age is being assessed or while suitable shelter is being identified. Children are sometimes detained with their parents or guardians on the basis of their later immigration status. We call on states to commit to ending the detention of children for immigration-related reasons. The best interest of the child shall be a primary consideration in all measures concerning children. Detention for immigration-related reasons of unaccompanied children and of family with children should be avoided. Detention of other vulnerable groups should also be avoided. The ICRC will continue to follow with interest the discussion on the issue of migration detention and stand ready to contribute to future work and reflection on this matter. Thank you for your attention.
Thank you, Ms. Valenza, for sharing with us the unique ICRC experience and also your unique perspective. We have now 11 minutes for discussion, so I will open the floor first for the discussion from the floor. When asking your question, please introduce yourself and eventually also the institution you represent. Thank you. Please.
My name is Jean-Michel Caudron. I come from the Conference of International Non-Governmental Organization. I'm in charge of coordinating the work on migration and North-South cooperation. Thank you very much, Pinar, for your testimonial. It was very emotional indeed. You have a great capacity of resilience and resistance, and I'm not sure that all the young migrants who are traumatized today have shown and will show this kind of resilience. If in 15 years or 20 years from now they're not feeling too well, if they felt that they were not really welcomed by the European society, what will they do then? I mean, don't we have to work on a sort of social contract with between the different generations? Shouldn't we make sure that these young people feel that they are welcome in the country, in the host country? Shouldn't we work with immigrant elderly persons who have not always been hosted and welcomed? They felt in exile, probably in a more exacerbated fashion, because there were no social media and social networks at the time. So possibly working on fundamental rights is the key. Working on the rule of law, on fundamental rights. This will help us preserve democracy for the future. Don't you agree?
Yeah, I think I agree with you. From my experience in Scotland, there is a lot of migration from Ireland, obviously from famine, but from people background of India and Pakistan and China as well. And I could say that from what I've seen on the ground, people are I don't like using the word, but people are quite integrated or adapted themselves to the society. And obviously, I think that there is a scope for research or to find out how people in the older generations see themselves being welcomed in the community. But I think I could say that at the moment, with the rise of the right-wing governments and with the rise of racism and fascism, a lot of people are being targeted for racism in the streets and within their communities. An example is even in Scotland, where we see it as a welcoming place, and obviously across the world as well. There was a case where an elderly person who was in the garden playing with their grandchild, and the walking person who passed said that we don't want you in our country, we don't want you to bomb us. So these are like simple things that the elderly generations and the younger generations face as well. But I think we could do maybe more. I don't know if there's any research or doing more work with the older generations to find out how they are settled and maybe learn from their experiences of what could be done and how they have managed to settle within the community. But I think there's a part of us, even though if you move to another country, there is always a part of us that is left behind in our homeland. And you are reminded that on a daily basis when questions are asked such as, but where are you really from? Oh, you've got a nice accent. Oh, you've got a nice accent, and where are you really from? And when I say, oh, I'm from Glasgow, they're like, oh, that's great, but I'm talking about your origin. Where is your origin from? So, you are reminded of the fact that you are different in the community.
Thank you, Pinar. I will now move to the questions at Slido. There's a hit parade, as you can see. So the first questions with 12 supports goes for Ms. Todorovska. Wouldn't it help enormously if CPT clearly stated that detention of migrant children is unacceptable, and what we hear now unacceptable as a rule?
Thank you very much for the question. As I mentioned, the CPT grounds its standards, statements, and reports based on findings during the visits. And the jurisprudence of the CPT has evolved in the past years based on such findings and such visits. We have, as I mentioned, been saying that detention of unaccompanied children should not take place in several reports, especially when there are poor material conditions, but not only because of that. Certainly there are developments in the direction where such as developments and discussions taking part in this conference, which would guide us to make such statements. However, the statements need to be in line with other parts of the Council of Europe and also through a discussion with the member states of the Council of Europe, because it's very easy to set a standards, but if you do not support states in implementing such standards, you will be having shortcomings and detention will indeed be taking place. I think there was a similar question which was related to non-detention of families. In this regards, I also want to add that CPT is part of the CJDAM, the Committee for Codification of International Standards in the area of immigration detention, and we pretty much contribute with our findings and experiences in order to reach to certain standards that would be applicable when it comes to prohibition or exceptional allowance of immigration detention of families or children. The next question, or shall we go to the Commission? Okay. Okay. The CPT has last visited Czech Republic in 2014, and indeed during the visit has visited the Bela Ježova Detention Center. In regards to the findings, as I recall from the report, there was only a father with 2 young children accommodated in Bela Ježova Center. The CPT has noted that Bela Ježova Center is equipped with sections which are suitable for catering activities with children. One of the concerns which was raised, I think, in regards to Bela Ježova is that the security has been seconded to external private security company. And that the staff of the security company hasn't received any training. The CPT recommended that the staff receives training for working with migrants. The next visit to the Czech Republic, it's a periodic visit scheduled for next year, and we will yet have to decide the program and see if Bela Ježova is again on the program for the visit next year.
Thank you. Let me read out now the next question, which is addressed probably to Nils. Nils Mužniek said that the detention of migrant children is not totally prohibited yet. Under what conditions is it still lawful then?
Yes, unfortunately, it is not prohibited. It should be prohibited. All member states of the Council of Europe have ratified the Convention on the Rights of the Child. which says that the best interest of the child should be the primary consideration in all matters, and the CRC has said that it is never in the best interest of the child to be detained. So there should be no child detention, migrant child detention in Europe. Unfortunately, this is not the case. You have partial prohibitions in some countries. For example, in Austria, no detention of children under the age of 14. Switzerland, no detention of children under the age of 15. But I don't know of any country where we have a complete ban on detention of migrant children in Europe. I might be mistaken here. Usually, it's framed as in exceptional cases, as a last resort, after alternatives have been examined for the shortest possible period of time. But as I said, even for a short period of time, it's quite traumatic. So we have a long ways to go here. And the recent data that FRA published are quite depressing, if you ask me. It just shows how widespread detention of children in Europe is.
Thank you very much, Commissioner, for your reply. Yeah, time's up. But I will take the last question still. The real legal solutions are absent. With no resettlement, repatriation, or family reunification prospect, aren't the smugglers the only real option for many? That's why I took this question, because the answer is very short. Yes, definitely, and we can see it. The people who work on the ground can see it on a daily basis. So definitely we are feeding the smugglers, in fact, by not having resettlement, repatriation, or family reunification prospects. So thank you very much. Sorry, Christos Akomopoulos still.
Thank you, Thomas. Just one word, because some of the questions relate to what the CPT is dealing with and whether it is legal or illegal, and what the CJ done, as Ms. Todorovska said. We have to realize that the CPT deals with conditions of detention, not with the legality as such. It may look into a legality. And the same thing is for the case law of the European Court of Human Rights, which again prohibits detention of children, not because it is illegal, but because it is amounting to an inhuman and degrading treatment under some circumstances. But for the time being, we have not yet had any, apart from the CRC comment, any clear instrument of international law prohibiting, for legal reasons, the detention of such. It is always linked to the conditions of detention and to the hardship created by the conditions. So I think that, and this is why we have this immigration detention conference, because we need to look into the legality aspects also, not only into the conditions. Thank you, Thomas.
No, thank you for very clearly indicating the way forward.